All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Thank you.
You seated?
Mr. Soar, could you come and remove this, please? Thank you. Good afternoon and welcome to the Court of Appeals. Your panel this afternoon consists of, to my right, Judge Fred Gore, to my left, Judge Darren Jackson. My name is John Tyson. We have two cases on the calendar this afternoon. We will take them in the order in which they appear. The first case that we have is Blackwell versus Blackwell. Are there any preliminary matters to come before the court before we get started? Okay, so with nothing further, we will hear from the appellant. Good afternoon, Ms. Connell.
Good afternoon, Your Honor.
Welcome, and let me, as a matter of personal privilege, I want to thank counsel for agreeing to the hour's delay in getting started. I literally just drove in from Hilton Head, and I needed the extra time, so through weather. So thank you for accommodating the court.
Glad you're here safely.
Thank you.
Judge Tyson, Judge Gore, Judge Jackson, my name is Michelle Connell. I represent the plaintiff appellate mother, Marla Zielinski, in this case, and I would like a 5-minute rebuttal if the court will please grant that.
Okay, thank you.
Thank you, Your Honor. This case is about the welfare of a child. This court's decision today is not only going to affect this child, however, it's going to affect the safety and the welfare of other children whose well-being and protection comes to the hands of a trial court. Our Supreme Court, in the case of Story versus Story, explains the rationale behind a trial court's duty when parents enter into a child custody agreement that's incorporated with a judgment or a consent order. And what the court has told us that the child is not a party to the parent's agreement or to the consent order, and the parents cannot contract away the trial court's jurisdiction. So with that in mind, the court's paramount consideration, its duty, is to protect children that don't have a voice in their parents' decision-making. This case really comes down to, well, if we're looking at the case in numbers, there are 2 sets of sealed documents, there are 2 counties, there are 3 judges, and there are 4 consent orders. And that's sort of the nutshell of it. There was a protective order entered by Judge Strickland in Mecklenburg County, and that was a result of Judge Strickland signing 9 subpoenas and issuing them to psychiatric, mental health, and medical providers. And they were placed under seal by consent. After that was entered, and those documents, let me go ahead and start making this point, were never reviewed by a court, were never considered by a trial court. They sat in their sealed documents, in their sealed folders.
Are those in the record?
Yes, sir, they are under seal with the 90 exhibits.
With the clerk's office?
Yes, sir.
Ms. Soar, we had not seen those if they're here. So if they are downstairs, would you please have them delivered? Go ahead and proceed. Thank you.
Counsel, is it fair to say that those documents were available for appellant mom to ask in other hearings prior to the last one for in-camera review?
Yes, sir, they were existent.
And is it fair to also say that mom probably was happy with the outcomes and chose not to use those in litigation because of her position that she was maintaining as the primary caretaker too as well, correct?
She received good orders prior to consent orders.
And after the change in primary custody, that's when mom wanted a review of those. Is that fair to say?
It was before that.
When was that in the record that it was before that?
It was in, I'm sorry, before that meeting, it was before the hearing. It was for the hearing to modify the permanent custody order.
But
That's what
prior
she
to that
requested.
hearing, Mom has never on the record asked for in-camera review at any other hearings prior to the last.
No, sir.
Let me ask you this also, just to give a clarification. On the custody modification petitions from both parties, was the substantial change of circumstances that were alleged related solely to the mother's move from North Carolina to Pennsylvania based upon her change of employment?
That was the primary reason, yes, sir.
Okay. Did either party allege any other basis for a change of circumstances?
The father alleged, essentially based on that as well.
Okay. So following up on Judge Gore's question, the original permanent custody order was entered as a consent judgment of the parties. Is that correct?
Yes, sir.
Based on consent.
Yes, sir.
And was there a finding in that order that the father was a fit and proper person to have custody of the child?
Yes, there were.
And at the time the permanent custody order was entered, were all facts and circumstances that were contained within the medical records available to the parties and to the court?
At the time of the permanent?
Yes.
Yes, sir.
Okay. So I guess that leads to my question is, if there had been some basis to challenge the father's fitness, wouldn't that have been the proper time to bring it up?
Yes, sir, and if I may address that a little more fully. First of all, just to back up with consent orders are entered multiple times in custody cases for the reason that the parents can come to an agreement with the terms, but the findings of fact can be omitted from the custody order. It's essentially a way of getting, if I wanted primary custody, I get primary custody and under terms, but I won't put the bad information about my ex-spouse in the custody agreement, and that's essentially how those come about, and they're appropriate and they're good. In this case, there was the finding, or there is a finding of fitness in this. However, if you look at the transcript that you have to look at the transcript just at the beginning. I think it's pages 13 through 17 and the modification. The attorney for the then father gave a rendition of what happened just before when the permanent custody trial occurred. And that was in February. It was supposed to be based on what this attorney is representing the judge. Excellent attorney, have no doubt that what he's saying. Represented to the judge, the modification judge, that the permanent custody trial had started. It was supposed to be about a 3-day trial. About 3 hours in, the judge calls the attorneys back in chambers and says that I'm no closer in deciding what's in the best interest of the child at this point, and you all need to go outside and figure this out. And I would suggest to you, Ms. Zielinski's attorney, and gave some directive that we don't know what it is based on what this attorney is telling the judge.
Is it fair to say, though, counsel, I guess in drawing it to the court's attention that there was a consent agreement that, in contrast to the Newsom ruling, that there was a separate order in contrast to Newsom, where it was incorporated into one apparent order from the facts of Newsom, that's different from the factual scenario of Newsom, that in this case we have a separate divorce decree and then a separate consent order where there's two separate identifiable orders? Is that fair to say?
It's fair to say they're different. I don't think they're indistinguishable. They're still consent
In Newsom,
orders.
no, I would agree with you, but as far as there are two succinct orders in this case, unlike Newsom, correct?
Correct, and like succinct orders, you mean the temporary custody order? And
Yeah,
then
regardless of whether it was, because there's so many orders in this one, but we don't have the orders incorporated into one order, which seems to be the facts in Newsom. In this one, we have separate temporary order, separate divorce decrees.
Correct, and then the final order is the permanent order is what this is focusing on. Yes, sir, Your Honor. And based on that, though, with the temporary order, it goes into some pretty specific detail about mother having primary custody and that father has to be drug tested, and the outcome of that order is very positive to mom and very positive to the child. And then with this second order, you'll look at the permanent order, it really doesn't address anything but the finances in that permanent order. It just sort of says this is what the arrangement's going to be. And so that's the order that was the basis of this modification order. And, Your Honors, the importance about this is, as I said, in these consent orders, you come to terms that's what in the best interest of the child, and sometimes you sacrifice what's in the findings of fact. That goes to two things in this case. First of all, the modification order does not address the circumstances that existed at the time that the permanent order was entered. And that's reversed, that should be reversed from that to make findings of fact because we can't tell how the case, there was a substantial change if we didn't know the original facts of what existed.
But didn't the trial judge say, in fact, that whatever facts were available when the permanent order was entered were basically subsumed in that order? Isn't that a fair description of what the trial judge said?
That she said that, but then if you look at finding of fact, and I believe it's 32, she goes on to state, and it may be 34, I apologize. She goes on to state that mother testified that during the marriage, father had a substance abuse issue. And then she states that mother testified that father was fired from his job at DSS because he allowed 2 children to be alone under his supervision, and one of those children sexually molested the other child. So DSS let him go. And the father denied that. He said, no, I retired. Well, if we look at the documents that are under seal from DSS, it absolutely states that that's the reason that father was released from his DSS.
Even if that's true, if that had had some impact on the custody order at the time it was entered, or if it had impact today, why wasn't that alleged as a basis for substantial change of circumstances? Either one.
Because at the time, the substantial change in this case was, in fact, the move. But if the court's going to understand how to protect this child, then it is, under Newsom, appropriate to go and look at the facts as they existed previously.
Were there any new allegations against the father of any inappropriate conduct?
No, sir.
I think the record reflects the father's remarried.
He is remarried.
And are there children that were brought into his home as a result of his remarriage?
Yes, there's 3 other children.
And was there any allegations as to any conduct that would be inappropriate by him to them or any other child?
Not about him with those children, no, sir.
Okay. Okay, so does the judge, when a motion is made for a change of custody based on changed conditions, isn't it fair to put the judge on notice of what those changed conditions are?
Yes, sir. That is part of the motion.
And the only thing the court had notice was a change of residence and a change of employment, or either a different job, same employer, different job, right?
Yes, sir. However, Your Honor, and I agree with all you said. In this case, though, it goes behind that, for lack of a better way of putting it, because the facts that exist in these sealed documents that no other judge has reviewed are crucial to the best interest of this child, and they are not res judicata.
Aren't they something that occurred 6-7 years ago?
They are, and Your Honor, if the trial court decides that they are too far removed and they are not important, his abuse, the substance abuse, if the molestation charge or something that the judge hears and decides that's not important, then that's the judge's discretion.
Would that be the same discretion not to visit items that predated the permanent custody order when there was a stipulation of being a fit and proper person too? Same abuse of discretion, right?
It would be the same abuse of discretion, yes, sir. But, Your Honor, again, to backtrack to the reason that we have these consent orders is to promote the well-being of the child. And if we can get to a consent order without these facts, then why would we go and litigate these cases? The cost of the litigation, the damage to the relationships, I mean, it's a lot. So in this case, the child was being protected at each step of the way, and then when it came to a time where these people are living in Pennsylvania and North Carolina, there's going to be some time, you know, mom can't protect the child anymore. So at that point, we need to look at what circumstances, who is this person that we're going to place this child in the custody of. And, Your Honor, going to...
Child's now how old? The child's 8 or 9 years old?
Yes, sir, born, it was 3.5, yes.
So a lot of the circumstances that occurred in 2013, 14, when the original order, a lot of that's just kind of not cured itself, but a lot of that may have been changed itself by the maturity of the child too, right?
It may have, but I don't think his substance abuse and his is leaving a child I mean, I think that it gets worse as they get older, that a child could be molested.
I guess,
under his
counsel,
care.
on that issue, sorry to step on your last question, Judge Tyson, but on that issue, hasn't there been a track record where the father was randomly drug screened by mom at her request at any time she wanted?
The temporary custody order allowed her to make those
Regardless
requests.
of which order, counsel, the question is it there a period of time in which mom had the ability to have dad drug screen? And from my understanding of the record, there were no negative screens or any screens that were actionable by mom as a result of her request, correct?
No, sir, not in the record, there is not, and not
Okay.
that I'm aware of.
And so, leaving the child unattended or those kind of allegations, is it also true that the change in the marital status, which was identified in the record, actually provided a more safe environment for the child versus being in a single-parent household at which that parent would be working, which there would be more stability for the child, and have step siblings as well? Wasn't that something that, and that's based upon what your allegation was, argument was right there. Isn't that something that the trial judge addressed in the order as well?
Yes, sir, address the remarriage of the father. Again, Your Honor, when you read these findings of fact, there's a lot of negative findings of fact about the mom. And when you look at those findings and look at those in a vacuum, they're negative comments, but are there negative character traits or negative behavior? However, if you look at that behavior from the foundation of these documents that are under seal, then you begin to understand what mom was doing to protect her child. And everything that she was doing was based on what she knew that father was capable of. And Your Honor, that's why I believe it's important. If the trial court did not want to fully throw out the evidence at trial, which I believe that would be an appropriate thing, and the trial could take them and dismiss them as the trial court wishes, at least look at these in camera to determine, is it something that should be reviewed? You know, Your Honor, you pointed out correctly that at no point along the way did someone, make a judge look at this because of the consent orders that were entered.
Well, let me ask you this. Now, on page 128 of volume 1 of the record,
Okay.
in addition to didn't the court order a parenting capacity evaluation independently of the stipulations too?
There was, yes, sir, a consent order for that.
Was that done? Was it completed?
Yes, by Dr. Geyer.
Was there any, for lack of a better word, red flags or any cautions that that came as a result of that report?
Yes, sir. The doctors pointed out that he has a substance abuse problem and that he would, because of the high amount of drugs in his system, that he should attend a 30-day rehabilitation
Okay.
to overcome that.
Did the court have that information before it, when it entered the custody order?
It was, I do not believe it was part of the sealed documents. I think that's one of the few documents that was not, and so the court did have that.
So I guess my question is, was the court and the parties fully aware of that as well, in addition to whatever consents that were made between them?
Of that particular document,
Yeah.
yes, sir.
I can appreciate that they both moved for change of custody based on changed circumstances. And a lot of that rests within the trial judge's discretion. We agree with that?
Yes, sir.
And your client came, on joint motions for change of custody. The trial judge, in its discretion, happened to rule against your client. So how do we overturn that?
Agree. The abuse of discretion would be under those circumstances. This, Your Honor, though, is a different issue, and it's a rare issue because it is asking the trial judge to follow its duty to look at the circumstances that are not res judicata and that should be resolved, all working toward the best interest of the children.
Would you agree that even if the judge reviewed everything that is in those sealed records and made the same conclusion that was made, would that not be within the trial judge's discretion to do that?
Generally, yes, sir. I don't know what the findings would be, but yes,
Right.
I understand what you're saying.
So how can you show prejudice? How can
I
you
show
show prejudice
Okay, I'm sorry.
if everything that the trial could, even if we were to order all those records to be looked at again, if the trial judge would make the same finding or same conclusion they made, how can you demonstrate any prejudice in the order that was entered?
Okay, I'm sorry. I think the judge could do that. I think in this case, without my crystal ball, though, I think that the judge, there's a reasonable probability that the judge could have changed her decision on this matter based on these sealed documents. There is a findings of fact, Your Honor, that, and again, I can't recall the exact finding of fact, I think it's 12 or 13, that the child had a therapist, and the therapist stated that she was concerned of the child being sexually harmed in the presence of the father, at the hands of the father. And it's on page 292, finding of fact number 13. And with that, Your Honor, that corroborates what were in these documents. You know, that all the drugs that this father had been taking, and, his out and out, when the judge says that she didn't believe the mom because dad retired and mom didn't present witnesses to support that, mom was barred from presenting the evidence. When she didn't have the sealed documents to show in the Dss letter that this is what happened. Father was tasked with supervising 2 children, and he observed the 2 children. One child sexually molests the other. I think that's pretty powerful, Your Honor. And yes, the judge could, in her discretion, have ignored that, but I believe it needs to be in front of the court. This is too important of an issue when we're talking about the best interests of the child. And
Doesn't finding of fact 12 right above that also said that whatever the father was not even told that the minor child was seeing a therapist?
yes, sir, and again.
So that fact was I mean, they both had joint rights to all information about the child, including medical care, correct?
Correct, and I believe at this time, mother had final decision-making authority.
But the father had a right of notice.
Absolutely, and Your Honor, I can't defend the contempt issues, and I understand that.
Is that weighing into the court's decision, you think?
I think it would.
Is it proper for the judge to do that based on the party's past conduct?
I believe that the court should consider all the conduct. And with that, I believe that's why these documents were so important, because mother's behavior, which would maybe offensive, and I would never advocate to violate a court order, but it may be more understandable when mother knew all this stuff that are in the sealed documents. And that's why she asked the judge to look at them.
Well, even if it was all true, wouldn't you agree the better time to have raised it would have been when the permanent order was being entered?
I do agree, Your Honor, but I think that Judge Osmond made it very clear that he was not interested in hearing the case based on what the trial attorney told this judge. And with that, the better strategic, is to pull out, get your consent order, make sure that you have primary custody of this child to protect the child as much as possible, and then rather than try to get a case. I mean, yes, absolutely. But that wasn't an option. That wasn't the best option for this child or for this mother.
So wouldn't it, counsel, say that in essence, the subsequent hearing was very similar to the first contempt hearing where mom made out really well considering her conduct? Wouldn't that hearing been a good, I guess, arena in light of the allegations against her to say, hey, judge, I know what is being alleged against me. I'm asking you to review in light of what is being alleged against me. Wouldn't that first hearing in that context been a good one to ask for in-camera review as well?
If at the contempt hearing, I don't think that would be, no, because it's her behavior is what's being reduced. I can't.
I think, did she
Say I
not
did-
file, did she not file a motion in regard? She filed a pleading in response to that, correct?
Yes, sir. But again, I think the contempt issue goes to her behavior, and you can't say, yeah, well, he was a bad guy too.
Well, hold on now, because that means you're talking both sides of your mouth on that one, because you just said that some of her conduct earlier was as a result of her fear of what dad is doing. So which is it?
Oh, I see what you're saying. Okay, I'm so sorry. And
So which is it?
what I've been arguing,
Okay.
and I agree. And I think that could have been something that came up. You're exactly right. But just because she did not bring it up, and I'm sorry, I'm into my rebuttal time, but if I may.
We've been peppering you pretty good, unless
Okay.
Judge Tyson says otherwise. I vote to give her.
Is this into her rebuttal, Mr. Sawyer? So you don't reserve the 5 minutes? Okay, all right. If you answer Judge Gore's question, then we will reserve time and be gracious on your rebuttal.
Sir. Yes, so I think that's correct, that would have been a time to bring it up. Would it have been a better time? I don't know. But the case law, Newsom does not dictate when you have to bring it up. It's the fact that it had not been, and I don't think she can, you can penalize her for not, in hindsight, doing one strategic thing over the other. And if I may, then, I'm sorry, did I?
No, you did.
Okay, she's asking.
Thank you.
Okay, thank you.
Thank you.
Thank you.
And we will stop the clock now, and also can you add 2 more minutes back to it, please? Just set it at 5 on the rebuttal, please.
Thank you, Judge.
Ms. Watts, good afternoon.
Afternoon.
Welcome to the court. I think you've heard the court's arguments, and I think you know kind of the questions that the court has, and I'm not going to dictate your argument, but I think you know what the court's concerns are.
Yes, Your Honor. All right.
You may proceed.
All right, may it please the court, I'm Rebecca Watts, and I represent the defendant, appellee Brian Blackwell. The custody order is on appeal to you guys right now because in February 2018, Ms. Zielinski wanted the trial she didn't finish in 2016. And that's clear, that she wanted to go back and have that trial she did not ever have.
Were you representing your client at that time, or did he have other counsel?
He had other counsel.
Do you, Ms. Connell has said that the judge appeared to want the parties to go out and, quote, work it out, and did not want to hear all the evidence. Is that consistent with what your reading is of the record, too?
It is, Your Honor, and that is not uncommon in Mecklenburg County for a judge to hear a little bit and then talk with the attorneys and say kind of, here's what I'm hearing, here's what I'm thinking, or do we need this time or not? I mean, the judge would have let them finish the trial had they wanted to. He's not forcing them.
Right.
But he's giving them a check-in. Here's what I'm thinking now based on what I've heard. You guys adjust accordingly. The interesting thing to me about the motions to modify, the change of circumstances alleged by both parties were that basically the mother moved. I think mother also alleged the child had started kindergarten, so that's kind of an age, school-related, making the current order unworkable.
Let me ask something, and
Yes.
it may be a rebuttal question. The plaintiff, her job was eliminated in North Carolina,
Yes,
but she was retained by the same employer for another position in Pennsylvania. Is that correct?
yes, yes, Your Honor.
So there was no change in employment, it was a change of position
Change.
and geography with the same
Change in
employer.
geography, yes, yes.
Okay.
She had to relocate for work, basically, to keep that job.
Now, the parties appeared to try to work out a mutually beneficial custody agreement. When did it start falling apart?
Well, I believe it started falling apart pretty much the same time that the typewritten order was entered. And because that was right about the same time Mom filed her motion to temporarily modify and said, I have to move. Because as soon as she moved, she started withholding. Visits, even though Dad was supposed to have every other weekend from Thursday to Monday, he went, I think, 4 or 5 months without seeing his daughter at all. I don't know if there was a complete absence of phone calls and FaceTime during that period as well, but I think it was, if there were any, it was limited and it was not what was provided for in the order.
This child was 2 or 3 years old at that time.
Right, right. And she, I think she is 9 now. She's 9 and a half. She will be, she'll be 10 in January. So she is well into elementary school now.
And there are step siblings, I guess you might say now, too.
There are 3.
And so the home, your client's remarried, and
Yes.
and his new wife had 3 children by prior marriage or relationship?
Yes.
And are their ages consistent with this child's age?
I believe they're older, not like 18, 20, but I think they are. I think they might be a little bit
Teenagers, maybe?
A little bit older, yeah.
What is the best interest of the child standard as it applies to parents who have a history of either drug abuse or alcohol abuse? And how does the court reconcile that?
So whether you're looking at an initial determination hearing or a modification hearing, if you are the best interest part, which you get to at a modification hearing after you find a change in circumstances, what is best for the child? You look at what is best for the child now, today, with these people standing here now, the situation as it is now. Ms. Connell talked about Mom knew what Dad was capable of. Standing there in 2018, she wants to talk about something that happened in 2011 with his job. This child was born in 2012. And you have, or you will have, the doc exhibits that talk about this supervision that he did of two siblings through DSS.
Was he a foster parent? Or
He,
was
he
it-
worked, he worked for DSS.
Oh, he actually
He
worked for DSS.
And instead of staying in the room, he was on the other side of the glass in an observation room. He did not just leave them. And I believe further in those records, it characterizes the contact between the siblings as a hug. So this is not a situation or a case where we have got a father who has been accused of molesting children. This is a DSS supervisor choosing to supervise from the next room, and the children touched each other at a visit. There's never been anyone find that he has done anything inappropriate to any child.
And this conduct occurred even prior to when this child was born.
Yes. Or, I think it though was, I don't know if it's 2011 that the records were from, but I think it was 2011, which would be before the child was born. Because remember, he was a stay-at-home dad for the first 13 to 15 months of the child's life, so he had stopped working around the time the child was born. And these drug issues, he was taking prescribed medication for diagnosed mental health issues. And that was during the marriage. That was 2012. That was 2013. That is not 2018. So if we're looking at, I guess I'm kind of a long way answering Your Honor's question about best interest, standing in front of that judge in 2018 saying, what is best for this child today? Do I need to know that dad had prescription drugs for mental health issues in 2012 and 2013? I need to know that if there is an allegation that now he is misusing or abusing prescription drugs. I need to know that if there's an allegation that then he was, but now he's not. I don't need to know that in a vacuum to decide what's best today. There's nothing in anybody's motions to modify that talk about it would not be in the child's best interest to be with dad because he's a drug addict. In fact, mother's motion to modify said he is a fit and proper person to have visitation. She says, I'm fit and proper to have primary custody in Pennsylvania. He's fit and proper to have visitation also in Pennsylvania.
So counsel,
Yes.
she answered yours?
I'm sorry, that was a really long, I don't know
It's
if that
fine.
answered your question.
Just go on.
I think you had gotten most of it from what I'm seeing, but my question to you is, if we get to the best interest and say that the judge did properly find substantial change, where in the order does it draw a nexus to the change of circumstance as it affects the child?
And that,
Which is what you would accept is required by our case law, correct?
that is required. There is some case law that talks about if the change is self-evident, then you don't have to actually put the words in. And I think the order makes it clear that due to mother moving and them living at least 8 hours apart by car, the order can no longer work. It can't. So it's not, and then it's not in the best interest of the child to have an order that doesn't work, or to have an order that's not being followed. So I would say that would be one of the self-evident sort of
I guess
nexus.
it could be argued that, but how does that affect the child? Again, being in that car 8 hours, great, but how does that affect the child?
It affects the child because she is not getting her time with father, because mother is withholding, because she would either have to miss school or spend less time with father. And I think at one point they adjusted the visitation schedule so she wouldn't miss school Fridays and Mondays.
And are those findings of fact, are they or are you getting that from the judge's order, the trial judge's order? I'm asking, is that nexus identified in the trial judge's order? to satisfy our requirement.
Them making temporary adjustments so the child would not miss school was in the transcript. I think they talked about that as things they had tried to do, and how even when they were doing that, mom would still be 2 hours late, would still be late. And I believe there are some findings about even when they tried to work around mother's move, that she did not make it workable. I believe that is in the order, and I will continue to look at that, but I wanted to be sure to talk about Newsome.
Before we go there,
Yes.
finding 33 on page 296, last sentence, mother testified she would return to North Carolina if the court awarded custody to the father. Has that happened?
From what I am hearing from my client, nothing is in the record. From what I'm hearing from my client, no, she is not in North
She's still
Carolina.
in Pennsylvania,
She's-
as
yeah.
far as you know.
And Ms. Connell will know for sure with her client, but my understanding is that she is still seeing the child in Pennsylvania, and that there are visits occurring in North Carolina.
Let me ask you this. If a judge found a party's contempt, could a judge find that a party's contempt was grounds in and of itself to change custody, would that be a lawful order?
Okay, this is a yes and no answer. If you are at a contempt hearing only, contempt, you cannot use contempt at a contempt hearing to then enter a contempt order that modifies custody.
Right.
But if you are at a custody hearing, the pattern of contempt can be taken in consideration by the judge in deciding what's best for the child. And because part of what's best for the child is whether the parents will foster loving relationships with the other parent. And that was also, I think, part of the Ramirez-Barker factors for the relocation case factors that the judge put in the order. So how mother behaved toward father and what she did with father's relationship with the child when she had primary custody is definitely an important part of what should happen going forward.
How much of that was related to the fact the parties were in different states? And is that in the order as well? You mentioned the 8-hour drive.
Well, the first 4 to 5 months that she was gone and they were in different states was complete withholding. And then at some point, they were doing some exchanges, so it was doable, but mother had just chosen not to. And then in the summer, they did their summer schedule after the first contempt hearing, and then after the summer, mom went back to withholding. So in being in different states, they were able to meet halfway for exchanges, and they did do that sometimes. But then once, I think the immediate scrutiny of the trial court was off, mom just stopped doing that. There's nothing here to say dad wasn't willing to do it, just mom withheld.
So that would be relevant as a basis to do a change of permanent custody?
Yes. And
That one party was not cooperating with the agreement as entered?
yes, and it's relevant, I think, for change of circumstances and for the best interest prong. Okay. Ms. Connell talked about Newsome, and in Newsome, the parties did have a separation agreement that was incorporated into a divorce decree. And then later, the question was, at a modification hearing, can we look back behind the separation agreement? And there, the decision was, well, requiring substantial change of circumstances, that's the rule because we want to prevent relitigation. You're not relitigating something that was never litigated, was never in order. So that was purely in a separation agreement context, not in a consent order context. But it has then evolved into cases involving custody orders and custody orders after trial. After Newsome was Waylaw, where there was another separation agreement that was incorporated. And one party said, you've got to go back. Newsom says you have to go back and look at these circumstances. And this court said, no, we don't, because everything that was known was known. In order to look back behind the separation agreement that was incorporated into the divorce judgment that became a custody order, you've got to show that all the relevant facts were not available. And that was another separation agreement case. But then Woodring was a custody order after a trial. And so it was a modification of a custody order. And there, the holding was you can only look back at what happened prior, look behind before the prior order if the events were previously undisclosed to the court. And it's a matter of whether it's res judicata, not a matter of whether the court has to. It's can the court. Can the trial court look back? Absolutely, the trial court can look back. Does the trial court have to? Does not have to. And that is in the nature of an evidentiary ruling, which is abuse of discretion. So what happened in 2011 has nothing to do with the alleged change in circumstances.
As alleged by either party.
As alleged by either party, or as found by the court. What happened in 2011, 2012, 2013 has nothing to do with what's best for the child in 2018, especially since in 2016, everybody's fit and proper. And even in Mom's motion to modify, she said he's fit and proper. She's not talking about his drug use in 2012 until she gets to trial. If there were such a concern, why wasn't there another parenting capacity evaluation? Why wasn't there something else? It was quite a bit of time between the motions being filed and the hearing on modification. There was plenty of time for discovery, for evaluations, for psychological treatment. To ask Dad, back in 2012 when you had prescription drugs and then the parental capacity evaluation said, maybe you need some help with that. Did you do that? That wasn't brought up. So she kind of goes back and forth between drugs and child abuse.
Are you saying that the 2011 evidence is not even relevant unless there was some new allegation brought where that evidence would support or bolster or add credibility to a later allegation? Is it a question of relevance?
I think it's kind of a twofold answer. I think that under Newsom and the cases after that say it is not res judicata to facts undisclosed, I think these are facts disclosed. So I think it is res judicata as to anything that happened before. I think you cannot look before. But even if you can look before, is it relevant? It is relevant only if it has something to do with what's going on now.
Some allegation
now
of reoccurrence.
Of reoccurrence or of a change. Say this was happening, but now this is happening. But one event that happened 7 years prior to the custody trial is only relevant if the trial court can use it to make the decision today about whether circumstances have changed or about whether what's in the best interest of the child. Because what's relevant today is have circumstances changed and what's in the best interest of the child today.
So under the evidence the trial court considers and the weight the trial court gives to that evidence is a matter of the trial court's discretion?
Yes, Your Honor.
So even if the trial judge, and I asked this question about prejudice, even if the trial court looked at all of it and came to the same result that there's been no allegation of a reoccurrence, and it's not based on the circumstances that are before me, would we review that order under an abuse of discretion standard?
I think so.
So where is the prejudice or where is the abuse?
I mean, on this side of the room, I see no prejudice and no abuse. The court exercised its discretion on what evidence to come in and made its decision. And, I think, Ms. Connell talks about, well, who knows, the judge may have decided something different if the judge had these facts. Reading the transcript in the order, it is very clear that the judge is focusing on what's happened in the last 2 years and how mom has behaved and what mom has done to the relationship between mom and the daughter. The judge specifically said, I don't care about what happened back then. Said, and just that also would have been a time for mom's attorney to say, well, you know what, judge, I'm going to make an offer of proof. You say you don't care about what happened before 2016, but let me make an offer of proof in case that might change your mind. I'm not saying she had to do that in order to preserve that issue for appeal, but I'm saying she did not do that. She could have done that. If that were the core of her argument, why not make an offer of proof?
Is your party under obligations of custody as it relates to the mother today?
I'm sorry, I don't understand.
Let me put it a different way. Does the mother have access in custody or visitation with the child?
Yes.
Today?
Yes. The mother does have visitation. I believe she's got a weekend a month in Pennsylvania and a weekend a month in North Carolina, and time in the summer and holidays. So it's more or less reversed from what it was when mom had primary and dad had every other weekend. I'm not saying it's every other weekend, but she has visits up there and visits down here, and then has time in the summer.
So her custody or her visitation, except for who has the primary custody, really has not changed?
You mean since the order was entered in 2018?
Right.
No, it has not. This has been, they've been operating under this order. And when the 2018 order was entered, it was to go into effect at the end of the school year.
Right.
So once it hit the end of the school year in the summer, and then next fall, so the fall of the 2018 school year, since then she's been living with dad in North Carolina.
Are there any pending motions or any pending matters in this case that are not before us?
There is a motion to modify child support because the original child support order was done with mom having primary custody and dad having visitation. And so after the new order was entered giving dad primary custody, he did file a motion to modify child support. That I've been told the hearing on that is tomorrow. The motion to modify child support hearing is tomorrow. So it's not been heard.
And I want you to comment a moment about the award of attorney's fees too. I think
Yes.
the parties conceded that am I correct? The parties have conceded that the issue needs to go back on that the order on attorney's fees is not sufficient?
Yes, Your Honor, the requisite findings are not there. The interested party acting in good faith and sufficient means. Here's the attorney's customary rate and how it compares with other, the language that needs to be there isn't there. That doesn't mean it doesn't exist. It just, the court did a shorthand, I think at one point, even when the court was giving its decision at the end, it's like, give me an affidavit. Do you want to leave a blank in the order? And some counties do kind of a freewheeling shorthand sort of attorney fee order where you submit your order with a line and they fill in an amount instead of having an actual attorney fee hearing. But I think, yeah, an actual hearing would be necessary for that.
Well, there have been several recent cases from this court that address that very issue too.
Yes, yes.
So you're not contesting the fact of the challenge to the deficiency in the award of attorney's fees?
Correct, correct.
So the case has got to go back no matter what?
It's got to go back on the issue of attorney fees. That is, you know, a 30-minute hearing on remand.
Going back to, if the judge, flip it around a moment, if the judge had looked at the sealed medical records and based upon whatever was in there, had made the decision, notwithstanding the contempt, to continue primary physical custody with the mother, would you be up here today arguing anything different than abuse of discretion on if the ruling had gone the other way?
No, Your Honor, because both of them alleged a substantial change in circumstances, and I think
The same conditions too?
with the same change in circumstances that the judge found, and so that's the legal question. That is the de novo review. That is what we're here for you guys to take a fresh look. And I think once you allege a change and the court says, yes, you're right, that has been a change, I don't think I can get up here and say, no, I'm just kidding, it's not a change. But then the actual custody decree is discretionary. I mean, some things you get up and say, well, it's discretionary, but the judge might need to say a little bit more to kind of explain it. You know, you see cases like that where it's not so much that the decision is the wrong one, it's that maybe there are some facts lacking that support the decision. I generally don't tend to bring those up here because the end result is, okay, go back and make those findings, and now what if, you know. But no, if the court had said, I'm looking at all these records, I'm having this full hearing, I don't care that mom has withheld the child, mom is still gonna have primary custody, dad, you're gonna have every other weekend up there, down here, and half the summer, and completely reversed, that would have been what it was. I don't see that we would have had grounds to challenge that.
When did your client remarry? Roughly.
I think the remarriage was in 2014, I want to say.
Was there any petition for change of, substantial change of conditions based on that fact?
No, they did
Would
not.
that have been enough to bring a motion to modify
A change,
based on the precedents?
just the fact that somebody has remarried, standing alone, doesn't constitute a substantial change. It can, but as a matter of law, you can't say this happened, it's a substantial change. And most of the things we look at with substantial change are kind of like that. It's like, you can't say for sure X happens, that is a change, because it does depend on, does this change have an effect on the child? So I think for a marriage, it would have to be he's remarried and has a great relationship with the stepmom, and you know, there would have to be
More to it.
more to it for the remarriage itself. It could be, but
You have about a minute left. I wanted you to take whatever time you needed to conclude your argument and for any questions by the court too.
I just would conclude with, you know, I think the trial court exercised its discretion in deciding not to look at evidence from 6, 7 years, 8 years prior, and properly found a substantial change and entered this order in the best interest of the child. And so we'd ask that you affirm that. And yes, the attorney fee does need to go back for a hearing on attorney fees. So,
Thank you.
Okay,
Thank you
thank you.
very much. Okay, Ms. Connell, I think, and Mr. Sawyer, you've reset the timer? Yes. Okay, thank you. You have 5 minutes.
Thank you, Your Honor. Just to clarify a couple of things, looking at document exhibit 951 about the DSS letter to Mr. Blackwell about the disciplinary issue, It states that in this letter to him, it says, however, during the visit on September 27, 2011, you left the children unattended by leaving the room. The older child fondled the younger child while you watched from an observation room. So it was more than just a hug, and that's part of the problem. Your Honors, I absolutely concede that if all these documents had been before the judge, and the judge decided this way, this is an abuse of discretion case, and even if the findings of fact aren't exactly there to get where we, to change, I tell my clients, we can win the battle, but we're not going to win the war, because it's going to go up to appeal. You may win, but you're going to come down, and then the trial court's going to make the correct findings of fact to support its order. Absolutely agree with that. That's not the case here.
How do you respond to the fact that there are no new allegations of similar conduct to warrant revisiting something that occurred 10 years ago?
Well, my response is thank goodness there aren't any new ones, because we don't want the child to go through this. But, Your Honor, what I heard from Ms. Watts over and over again is mom withheld the child. Mom's behavior was considered as of today. And I understand that, and Judge Gore, to your point, that why? Why was mom doing that? And I think it's incumbent on the trial court to say, okay, mom's behaving this way, it's a little bit unusual. She's moved to Pennsylvania, where her family is also, but she moved because of her job. And now she doesn't have these consent orders that she's going to protect their child. She's going to be too far away to have primary custody if she doesn't do something. And that's where the trial court needed to step in and say, okay, let's all take a breath. Let's figure out what's in the best interest of the child. Clearly, you've moved, substantial change of circumstances because it's so far away, but why is mom doing this? And
Would it have been better for her to have, rather than not comply with the orders that was agreed to, wouldn't it have been better for her to have come back and brought allegations or tried to move for substantial change and not just disregard the orders that she was under?
Absolutely. I think you should always comply with the orders.
Right.
I understand that. I also understand being a mom, and you don't always make the best decisions when you feel like your child's in danger. But yes. But again, Your Honor, when the consent orders were in place.
So with that last argument, counsel, whenever she thinks her child's in danger, is that not fair for the trial judge evaluating all those factors and considering the lack of current allegations? Isn't it also fair for the trial judge to evaluate the reasonableness of mom's conduct at current time frame as a parent? Because if she's being considered unreasonable because of this remote conduct in light of no current conduct, can't the trial judge use that conduct that would cut against mom and her making decisions? As you're saying, she's protecting her child, but couldn't that overprotectiveness and the effects on the child hurt mom as well? And wouldn't a trial judge be able to use those factors to evaluate mom's reasonableness?
Yes, sir, absolutely. If the trial judge knew the basis for the conduct, and that's the
Who has
issue
the
before
burden to
court.
bring that to the court's attention?
Excuse me?
Who has the burden to bring that to the court's attention?
The sealed documents?
No, who would have the burden to bring that back before the court to say, this is the reason I'm behaving this way?
I believe that would be on the mother to prove that.
And she didn't do that, did she?
She was trying to when she was trying to get the documents before the judge. But the judge didn't consider them in camera and didn't consider them for the trial.
But that was not a basis in her motion either, was it?
No, it was not part of it was part of it was because she took a job. She had to take her job.
Were the parties compliant when they both were in North Carolina? I know that the transfer happened soon after the order was entered, correct?
Yes. I am aware that contempt motions were filed, I believe, by both parties, is what the order, what the record showed, but I cannot
The exact
confirm
timeline.
exactly what the timeline is. I see that I'm out of time.
Would you
Thank so
take a
much.
moment to sum up?
And if I may be so bold, I just would ask this court's direction, maybe in its opinion. A SIR reply brief was filed in this case, and without a motion, I'm not sure what a SIR reply brief is, and I didn't know if the court could give us any direction on that in considering it, because it's not in the rules, and it expands the ability to continue the argument for the appellee. So I just as an appellate practicer. But in this case, Your Honor,
If you filed a motion to disregard or dismiss it,
I would say there's no basis for it, but if it was going to be filed, maybe a motion to the court to say, I would like to file a SIR reply brief, and then get the order to court. But more to the point, Your Honor, I do think that this is a very unique issue for the court to consider. It goes back to the duty of the trial court, and I understand that mom's behavior came into play on this. I understand that the initial circumstances existing at the time were not part of the motion, but that's not how substantial change of motions or modification motions work. But this is an opportunity for the court to, request that all the evidence be heard, existing at the time throughout the child's life before ruling, if so requested. Thank you so much for your time.
thank you for your arguments. Thank you both for your arguments. We will take a brief recess in order for the streaming. You wish a break or just stay? You want to take a break? Okay, the court will stand in recess for about 5 minutes. Thank you again. County Jail.
And the court will be in recess.